Hey there, welcome to our AP Legal Zone podcast, brought to you by AP Lawyers. We are your top fix for all weekly law updates, including family, immigration, wills, and estates law. Just a friendly reminder, we are not your lawyers, and everything contained in this podcast is for entertainment purposes only and not to be construed as legal advice. Be sure to subscribe to our podcast so you can stay connected with any updates and get notified about our new episodes.
Hello, I'm Angela Princewill.
And I'm Sherine Abdi.
And our topic for today is unequal division of net family property. And by way of a quick intro, if you're going through a separation or divorce and you're equalizing your properties, well, it's what you're required to do, but clearly you could choose to do it or not do it. But if you're in the process of equalization, there's times when in the course of disclosure, it might occur to you that maybe a straight out equalization is unconscionable. And I know that sounds like I'm using a big word, but it's for a reason. So if it's unconscionable and if the circumstances are right, you may be entitled to pursue sort of a claim for an unequal division of net family property. It's not an easy claim to succeed on, and there's a lot of factors. I would have Sherine kind of read through what the act says, and then we would go through each factor one after the other. Take it away, Sherine.
Yeah, so basing on what you've talked about, I think it's also important, we do have another episode on equalization. So if you don't really have that background or really know what equalization is, I think it's imperative that you go watch that episode first or listen to that episode and then come back and maybe see if this applies to you.
Yeah.
But as Angela said, the court can award an amount that is different than the equalization amount, having regard to several different factors. One of them being a spouse's failure to disclose to the other spouse debts or liabilities existing at the date of marriage. The fact that debts or liabilities claimed in the reduction of a spouse's net family property were incurred recklessly or in bad faith. And another factor is a part of a spouse's NFP, I'm referring to net family property, that consists of gifts made by the other spouse. Another factor being the spouse's intentional or reckless depletion of his or her net family property. And the fact that the amount of the spouse would otherwise receive is disproportionately large based on the period of cohabitation being less than 5 years. And the fact that one spouse incurred a disproportionately large amount of debts or liabilities other than the other spouse for the support of the family. Another factor being a written agreement between the spouses that is not a domestic contract, and any other circumstances related to the acquisition, disposition, preservation, maintenance, and improvement of property. So that's a lot we just threw at you.
Yep, it is. It is. And I think the starting point of all of that is the court may award a share that's an amount that's more or less than half the difference between the net family properties if the court is of the opinion that equalizing the net family property would be unconscionable. So one of these factors that Sherine has just mentioned, which is about 8 of them, and we will go over each one. But even though it applies to you, if the result is not unconscionable, it doesn't matter.
Yeah, so if it's just unfair, or just unjust to you, it may not meet that high threshold.
No, it will not. Yeah, just call it as it is.
It may not. It has to be what the court refers shocking to one's conscience, and that is the meaning of unconscionable.
Yes. So I remember many years ago I had a case where you and I were working on this file, and I think it was a swimming pool, and that had to be fixed. I don't know if it was close to $10,000. It was an amount that was significant to our client for sure, not
to the party particularly,
not trivial for us as well. But we understood that it was, while it's a lot of money and it's unfair, but we were saying it's not unconscionable. But I mean, just because we wanted we got the judge to kind of give her input on this issue, and she just wouldn't have it. And even though we had tried to prepare the client for this outcome, she was shocked. She's like, what did she mean? It's a lot of money. And we're like, yeah, but it's it's not shocking to the court's conscience that a
Yeah.
person spent, almost $10,000,
Maintaining
maintaining a
or
pool. It was,
repairing a
and
pool.
again, it I guess it also depends, right? In this case, the house was 1 point something million, and that was before. This
It
is
was a
few.
big selling feature for the
Well,
home.
yeah.
She had incurred a significant amount to her to renovate the
And the courts
pool
did not
and
think it was
repair.
the main thing. They didn't think it was shocking, and I think I want to put that in context because that amount may be shocking for in another context, right? And again, this is, I know anyone listening to this like in 2021 is thinking, well, 1 point something million home in Toronto, that's a shack. But no, this was a few years back
Yeah,
when
this was when they were actually
you could get a decent home
very
for that
good
amount.
value for your dollar there.
Yeah, so well, you know what's interesting? We didn't even really think so then, but
I mean, yeah. Now we're thinking, wow, we just got it. Like the people who bought properties 2 years ago are thinking they got a steal, but
no kidding. But this is not a real estate segment, so we're gonna move on.
yeah, I think. Do you want to go over each individual
Yes.
one? Okay.
Okay, so starting with the first one. So a court would do a variation. And remember, you can, when we're talking variation here, again, for those that aren't very grounded on the equalization thing, when you separate, the courts the goal is to make sure you both live with half of your assets each, both people. So when they calculate assets in your name and assets in the other person's name, whoever has the greater amount left split what's the difference with the other party so that you live equally.
Yeah.
So what we're talking about today is a situation where you're saying, no, I don't think
It's
us
fair,
living
or-
equally is appropriate in these circumstances. I should get more. Well, the court does say less. I don't know whoever asked for less, but I guess less for the other party. But that's the whole idea is we're trying to vary it and not have both parties live equally. Okay. So the first factor, a spouse's failure to disclose to the other spouse debts or other liabilities existing at the date of the marriage.
Yeah, I mean that's pretty self-explanatory.
Yeah, no, but they might not understand the significance, right? And the significance of this is when we're calculating equalization and when you're preparing your financial statements, things like that, the debts that you have on the date of marriage is part of the factors that go into equalization. So we look into your assets owned at the date of marriage, your debts owned and things like that. So if you have a significant debt or whatever, like it might affect the equalization in one way or the other, right? Can you think of another scenario that this might be significant?
Like other than a debt?
No, I'm saying in this, like that's the best example I can think of at this point to
I can't
explain,
really top yours.
Yeah,
I mean,
to explain why
yeah.
the failure to disclose this debt at the date of marriage might be justified, right?
Because what you're equalizing is your assets, your debts, and your liabilities at 2 points of time, really. Your date of marriage and your date of separation. So all of these dates and those values will all play a consideration in how much equalization is payable, and what you can deduct and what would increase the calculation or decrease the calculation. So yes, it would be an issue.
So the second one is the fact that the debts or other liabilities claimed in reduction of a spouse's net family property were incurred recklessly or in bad faith.
Yeah, so I think a recent example I could say of maybe if a party is gambling, a significant portion of their net family property, and like recklessly so, like if someone has an expensive hobby. I think that was one of the issues we dealt with.
I think that one I think of more in terms of reckless depletion, though. When I think here, because this is just debt or liability, so a person can recklessly deplete assets without necessarily incurring debts. But I think an example that comes to mind for me that would fit probably more into this example is of debts that are claimed in reducing the net family property. It's say a person goes into a business, someone just decides to start a business that has no reasonable prospects of success.
Yeah, well.
And now you incur so much debt, and so it's reckless. It might not be in bad faith, but it's reckless. So now it reduces, and you think about this strategically now, it reduces your NFP at the date of marriage, but that business may potentially pick up in the future. And now, so if my client comes to me saying, my wife has started this business, and she started this business how many years ago? It's just she's wrapped up like $50,000 to $500,000 in debt. The business is worth nothing or whatever. But now when we do the net family property, it's that debt has essentially wiped off
Yeah,
all of the assets, you know?
especially if maybe your matrimonial home is not owned jointly and it's solely in that party's name. Let's say they took out a significant portion from maybe the line of credit attached to the home or refinance the mortgage.
Yeah.
And then they put that debt into, like you said, a business or something like
Yeah.
that. So yeah, it would
And
definitely
just
impact.
imagine in this scenario of the business as well, they're going to there's what if that business picks up 3 years after we've completed equalization? So in that scenario, I would definitely be pushing for a variation, because the business can pick up, but I'm not there to get the benefits of that business when it picks up. But I have suffered in the fact that I lost out on an equalization amount that I could
Yeah.
get. So yeah, so anyway, that's kind of my thought there. What's the third factor?
A part of a spouse's net family property that consists of gifts made by the other spouse.
I mean, it is what it is.
Yeah.
I mean, if someone's gifting you, you know, because if someone's,
If
especially,
it's a true gift, like if it meets the intention of a gift or the characteristics of a gift, yeah, I would understand like it being part of your spouse's net family property to unnecessarily maybe increase, you know, their NFP, then obviously something that worth considering, a variation.
this is not one that I find a
Yeah,
lot.
it's not one that comes
Because
up
even
often.
when gifts come up for me, it's usually in the context of I want
And an exclusion.
yeah, or even
Or a
or
deduction.
somebody wants their ring back or something along those lines, right? So, but it's something that's available for us to rely on when and if we do need it. Another factor is a spouse's intentional or reckless depletion of his or her family property. I think your
This
gambling
is where,
example
yeah,
is
my
perfect
gambling
here.
example would have worked
Yeah.
better here.
No, but tell us more, because I think I cut you off there when
I did have a recent issue with this, and I think the parties actually had won the lottery, which I know we're not lucky enough
Yay,
to
good
do.
for them.
I mean, good for them until you hear the story, but ideally, yeah, like they won the lottery.
How
They
much
won
did they
about
win?
just shy of $1 million.
Oh, wow.
And then, you know, the husband had a severe gambling problem. So they had all this money in like I think a mutual fund at the time. He depleted it by his gambling addiction by more than half of the amount that they won over the course of I think 5 years. So, you know, that would have been a great circumstance where I would say that would be unconscionable. But
So the money went from almost $1 million to less
to
than.
less than that. So I think they about had $200,000
No way.
in total to share. So it's a
Yes.
significant
Yes.
depletion for sure. And that was reckless, of course. Like
I mean,
gambling
like,
is
come
not
on.
it's not like an investment, of
If
course.
not
It's definitely
if not intentional. Like,
Yes.
God. Yeah, absolutely. Yeah, that's a great example. I can't even top that one, but
Yeah.
that's because a lot of my a lot of times when clients have spoken to me trying to, you know, claim reckless depletion, I've never had anything at the scale at which you're describing.
Yeah.
Some people would have had people, you know, talk about Lego collection.
or like
I had no
RV.
idea how expensive like Lego
Oh.
collection could get. Like, but
People have
obviously it's
expensive hobbies. And
you-
that's the thing, a lot of people will say, well, he spent maybe $40,000 on tools over the course of 20 something years.
only
Now,
in the course of a year, like 20,000.
yeah, on tools which do have value. So
Exactly.
like they would be attributable to on his
Mhm.
NFP somehow. But yeah, like
Exactly. So that's another thing. Like, so when you talk to us, we try to find the line of when I say path of least
yes,
resistance.
that's the most common quote.
Yeah, because why do we want? You know, you might come to us and you're insisting on us fighting over. I don't want to use the word fighting for a negative connotation, but just you're trying to make sure that we get you what you're entitled to. This person has spent so much on tools, and you know maybe it's not even a handyman. There's no value to this, and in your mind, but rather than maybe asking for an unequal share of equalization, we may rather go the other way and say include the value.
Yes.
you
Get them
know,
appraised.
Yes, so things like that. So we might rather get the tools valued and added to the NFP rather than going this route, because that will be the path of least resistance. But let's say they bought something as, I don't know if Legos. What
like
there's some things
or
that
like a lot to like
there's some things that
people have
depreciate so fast that
it's
we
like
can't
vehicles.
save it.
Like someone has like a vehicle obsession, and obviously when I see like reckless depletion, I mean like there are debts like
You guys have 6 cars.
you have significant debts, and
Yeah.
instead of paying off those debts, you're incurring more by
To fund your habits.
yes, and like it's not uncommon that people have like a motorcycle collection
Yes,
or
that's true.
like a sea-doo. I don't what are those called? To be
Yeah.
honest, I don't even know.
Yeah,
Those
yeah.
recreational water activity vehicles. That's a long-winded answer, but I'm sure someone's laughing because they know the exact word I'm looking for, but that's fine.
Yeah, no, yeah. So if those things they deplete in value, we even if we try to put the current value of the on the NFP, it doesn't kind of make up for what's happened here, and it's unconscionable again, not simply unfair. It's shocking to the conscience if you have, an average middle class family, and in maybe each party maybe earning $40,000-$50,000 each, and you have 6 cars, and one person's like buying like all of these like motorcycles. I don't know if they increase in value, so if they do, this is a bad example, but you know what we mean.
No, but they normally decrease, especially like if you're separating 20 years down the line. Like that's not helping you in terms of getting that value.
Okay, so I want to be careful with you using 20 years because it would not qualify as intentional depletion. Like if someone's acquiring something over the course of 20 years, first, like the courts don't want to hear that, right? It's like it happened while you were married. So, but we want something a little bit closer to the time of separation.
and
something
have
that's
it over 20 years.
a lot more like ridiculous. An asset that does not increase in value or that depreciates in value.
And so it was reckless, right?
And not just unfair, but it's, if a court hears it or if an objective third party hears it.
Yeah, if you've condoned the behavior, if you've kind of, assisted maybe or enjoyed, let's just use them
with them.
Yes, like, or your children enjoyed it was a family kind of consideration, then of course, like, it's not really reckless in the sense that, yes, it may have been reckless for the two of you, but I mean,
it's not the other part. Yes. It's not the other part. It's just your lifestyle, and that's the reality. Like a lot of people, if we all go through each other's budgets, we would definitely come up with something that we think the other person is doing that is ridiculous for sure. But that's you do you, I'll do me, and that's all well and good. But when we're talking in the context of a separation, it has to be something that you never agreed to and you've objected to, and you can't have condoned it for the last
like
even
how
10
many years. Yeah.
So, okay, just wanted to clear the air there. Where were we?
This is probably the most common one. Would you agree?
Which one?
The fact that the amount a spouse would otherwise receive is disproportionately large in relation to the period of cohabitation.
That is less than 5 years.
That is less than 5 years. That is most important.
Yes, that's the most important part.
I love that.
I don't know if it's always the one. I don't know if it's the most common, the one that jumps out to us the most because
it's the most prevalent, I imagine,
for us. Because it just spells for us. It just spells this is not fair. Is it unconscionable? But yeah, so just so you understand where we're coming from. Imagine, you're married to someone. You guys got married 3 years ago. No marriage contracts, nothing, and now you have. You brought into this marriage a matrimonial home. Matrimonial home now worth $2 million. Based on normal rules of equalization, holding every other thing constant, and you have a $2 million home, no mortgage, just take everything out of the picture. So now this person is entitled to $1 million for being married to you for 3 years.
Mm-hmm.
Even let's call it 500,000. It's still somewhat shocking to me. So I want to explore those and I shouldn't even say just married, a period of cohabitation. So I want to be very careful there because sometimes we try to tack on like times where people cohabited before marriage, or I'm more famous for trying to discount time for when people were married but didn't really live together, and I only want to look at the period of actual cohabitation because that happens for a lot of people that sponsor their spouses. So
like think of maybe a year marriage, but maybe 6 month cohabitation or something prior to, or in the opposite, think of maybe a 5-year cohabitation and a 1-year marriage.
No, I mean, for me, it
Which,
jumps out all the time when we
yeah.
have our clients. Like, I mean, we have an immigration department here. So, you know, it's exciting when people's spouses come. But imagine if they have to go through a separation 2 years after, and you're new to the country. You know, you're settling in, clearly giving up a lot to come here to join your spouse. But the unfortunate thing is the spouse is the one here with a matrimonial home that now has to be split. And again, we're not suggesting that there's any foul play on any one side. We're just saying if our client is having this conversation with us, we're definitely going to look at whether it's unconscionable that you should live with that. Now, in the spirit of just kind of quantifying shock here, let's say the person is getting $50,000 from the matrimonial home for a 1-year marriage. I don't think that's shocking. Mm-hmm. I know it's a huge amount and I'm just fitting it out there, but I'm just saying, I'm just trying to kind of put things in context here.
Yeah, I mean, I think the leading case on this was about 260,000. Similar circumstance brought in the matrimonial home into the marriage. The full equalization payment was about 260,000. The court ended up, she was asking either that or a variation based on a percentage of 4 out of the 5 years that they were together. But instead, the court only gave her 60,000. So it's not so much the amount. Sometimes it's a fact-driven situation. It's all scenario-based. Like it's not just one paint of one stroke of a brush, and then that's what's going to happen.
Yeah, so in some cases it doesn't matter. It might be appropriate to get that to 60.
50,000, I don't know, but the amount may end up being 60,000. But would 50,000 or 60,000 be unconscionable from the onset? That I can't see, but again, you never know.
Yeah, no, I'm glad you definitely clarified that for sure, because it's all fact specific, right? But here's another scenario that I've found that's happening a lot. So someone would, once you cross that 5-year threshold, it gets more interesting. So I have had clients that have been, that's been, I don't know, 5.5 years or 6 years. And obviously, it's so close to the 5-year mark, and the other side is obviously not thrilled to have to pay the full equalization amount. I mean, again, thinking in that scenario, being married to someone for 6 years and maybe not financially contributing, or maybe we don't even have the other markers of a traditional marriage in that sense, and now that party might feel, well, it's unfair for him or her to just walk away with $260,000, right? But we don't make the laws. We're here to try to help squeeze your case, your situation in the most favorable way under the law. But that 5 years is significant.
It is. And based off like that particular scenario that you mentioned, like maybe the next scenario would help, which is the fact that one spouse has incurred a disproportionately large amount of debts or other liabilities for the other spouse in support of the family. So, for example, if maybe there's a huge debt that a party has to take on, it would be unfair because he's had to support or she's had to support the family that entire period. Yeah. Maybe they just met that 6-year threshold that you're talking about.
But to even paint a fuller picture, right? This is why this is important, is when you're doing your NF, people don't share debt. So people come and when I'm sure that this happens to you a lot, they're like, yeah, we have, $50,000 line of credit. I want to share that. We have a car. I want to share. And we're like, yeah, it's all good, but we don't share individual assets and we never share debt.
Unless it's joint.
Yes, unless it's in both your names. Yeah. So then it's shared. But if one person has, but usually it's one person has a debt and they're like, well, he told me he was going to do this. Yes. Or it's in your name, it's yours, except the other party agrees with you. So the problem with this scenario is when you're doing the NFP calculations or whatever, even if if it turns out you have a negative $1 million situation, we're not going to divide that negative amount. It just all comes down to zero. So if it happens in such a way that you have so much debt and you're stuck with it, and it doesn't matter how much so imagine if you have $1 million in debt, and the other person even gives you an equalization of 260,000. It doesn't offset the debt that you're keeping at all, because you're holding. We can't divide your debt. Once you cross zero, we stop at zero. We can't deal with negative numbers. No. And now the other person has like this positive number, but it's still it's not balanced in here. And this debt was incurred because, the family has been used to living a certain lifestyle. Maybe you guys agreed to continue to maintain that lifestyle, and now
maybe you paid off all of the other spouse's debts. Very common.
Yeah.
By using that line of credit or that debt, that loan that you have. So yeah.
So in that scenario, it's definitely worth seeing if this section would be applicable to you for sure. And Shirine's favorite, are we there yet? Oh, okay, no, we're not there yet.
Written agreement between the spouses that is not a domestic contract. What I can think of here is maybe like a trust declaration or something in particular respecting.
Maybe, the way I interpret it, and I've never actually had to also deal with this, is when, how parties come to an agreement, but it doesn't meet the criteria of a domestic contract, but it is still an agreement between the parties. It's something that could just be discounted. So when people do, so if you have a marriage contract, for example, that's not a valid domestic contract because of whatever elements are missing, but it still kind of shows your intent, and you're saying, well, the intent was never for her to get this or that. While your contract might not be enforceable, this section might allow you be able to reduce the amount of equalization that person gets. Okay. And Shirine's all-time favorite.
The one I feel like we use second most often. Or actually, and maybe the other one fails, we use this one.
Yes, when we're past the 5-year threshold.
Yeah, and there's a property, this is where we usually go. And it's any other circumstances relating to the acquisition, disposition, preservation, maintenance, or improvement of property.
Like, now you see why we have this is like okay, let's see how can we make it fit, right? Because as we had said earlier, if the 5 years has passed and you still think it's unfair, and I'm deliberately using the word unfair here, and then we would look to see, okay, is it unconscionable given the fact that you acquired this property, you preserved it, the other party didn't contribute to maintaining it in any way, and things like that. So this is the common section.
Probably like investment properties that maybe that spouse had nothing to do with it. We've
had people that have come in with investment properties into the marriage, and you're right.
The other party wanting an equal share. Obviously, that's not what we. Not if that's our client.
It always depends on who's our client.
But yes, this is like the most common one that we would have used.
Yeah. So I guess that's it. Do you have anything to add?
No, I think that's everything.
Okay, so we've done an in-depth discussion of Section 5, Sub 6 of the Family Law Act, and that's where you would find that's where you would go to if you believe that your an equalization of your net family properties is unconscionable. Go through the factors. As we said, it's all fact driven, and if you talk to us, it's our role to advise you on how we can get how your facts can fit into these scenarios, or frankly, honesty is the best policy. If we don't think that you meet the test for unconscionability, we will let you know, like, right off the bat. And on that note, we'll sign off for now. Have a wonderful day.
Bye.
Thanks for listening and joining us in the AP Legal Zone. We hope you enjoyed this episode. You can find more episodes by searching AP Legal Zone on anywhere you watch podcasts. Be sure to subscribe to our podcast today so you can stay connected with any updates and get notified about any new episodes.